to follow and in fact contribute to employee safety and respect in the DC government workplace. Let me begin today's roundtable by informing that during the month of August, I surveyed the DC government operating and independent agencies regarding sexual harassment complaints and claims, and each agency's work posture using the mayor's old order of 2017. And I received responses from all but a few, including the Office of the City Administrator, the Office of Disability Rights, the Deputy Mayor for Health and Human Services, and the Deputy Mayor for Public Safety. For completeness, this committee still welcomes these agencies' response to the survey. Moreover, the committee reviewed the DC Council's sexual harassment policy and the District of Columbia Court's Joint Committee on Judicial Administrative Personnel Policies that their staffs follow. Copies of these policies will be entered into the hearing record. The disposition of claims or employee complaints was not made available to the committee from these two entities. After evaluating the survey results containing 354 allegations, that is, 277 were verbal, 77 were physical, that accumulated from the time of the original mayor's order of 2017 and was instituted through September 2023. I conducted a working group meeting with a few of the mayor's accountability agencies, the Office of Human Rights, Department of Human Resources, and representatives from large agencies that have posted complaints, including the Metropolitan Police Department, to discuss some common sense ideas for improving our standards. I believe these discussions provided some input in the revised, newly released Mayor's Order 2023-131. Mayor Bowser is commended for incorporating into the order ideas discussed by the various general counsels during that working group meeting. Specifically, the updated Mayor's Order 2023-131 establishes a sexual harassment task force, similar to the working group in size and number, to further examine the district's sexual harassment policies by, one, providing recommendations to further the goal of a harassment-free workplace, two, establishing obligations of district government employees, three, adding all of the mayor's direct report personnel to the requirement of referrals to outside investigation of sexual harassment, and four, banning all sexual and romantic relationships between supervisors and the employees in their chain of command. I also appreciate that the updated Mayor's Order 2023-131 makes very clear and distinct that the issue it aims to address involve dating, romantic, or sexual relationships, not other types of platonic relationships or friendships that naturally develop in the workplace. As we discuss the district government's sexual harassment policies and procedures today, concerns about the overall workplace culture, including bullying, retaliation, and favoritism, may be raised. While today's hearing is focused exclusively on the handling of sexual harassment claims, other allegations may be examined at another time. Additionally, while some tuning in today's hearing wish to hear about the recent allegations involving some senior level government officials or any other matters under investigation, that is not the charge of this committee nor this hearing. Instead, today's roundtable is focused on the interpretation and utilization of current and updated regulations on DC government's response to sexual harassment in the workplace. Specifically, today we will discuss the recently released Mayor's Order 2023-131, which supersedes the previous order of 2017-313. To understand the current climate of our workforce, especially as we continue to move into a post-pandemic era. As chairperson of the Committee on Executive Administration and Labor, I am responsible for oversight of the entire district government's workforce and a number of other accountability and senior level agencies, such as the Office of Inspector General, the Board of Ethics and Government Accountability, Department of Human Resources, the Mayor's Office of Legal Counsel, and Executive Office of the Mayor, and the Office of City Administrator. The district government is a workforce of approximately 34,000 individuals across all agencies, which is approximately 5% of the entire Washington, D.C. population. This is no small number, and it is very important that we ensure our workplaces are free of sexual or other forms of harassment and strive to improve all of our professional experiences. Within each department, office, and division, we have many high quality and exceptional individuals working to serve the residents of the District of Columbia and the city as a whole. Regardless of whether our employees interact directly with the public or if they are unknown faces, each district government employee serves an important role in serving our unique city and deserves to work in a safe and healthy environment. I am interested also today in learning about how our government agencies are currently operating and how they plan to implement the updated order to eliminate any issues of sexual harassment in our workplaces, while also sharing whether at this point any unforeseen shortfalls or potentially unaddressed situations between employees has not been covered in the newly revised Mayor's Order 2023-131. In conjunction to the revised Mayor's Order, I will also review the council's and the DC Court's policies to strive for a unified approach in addressing sexual harassment. For today's roundtable, we have 8 district agencies, of which 6 are present today. DC Public Schools declined to participate, and the Metropolitan Police Department could not attend due to a scheduling conflict for a previously scheduled conference. Although DC Public Schools declined to participate, I'm still interested in learning about the sexual harassment occurrences in our schools, which are filled with our children and our teachers. With that said, today's roundtable open to testimony from DC government personnel only. We'll begin with panel 1 of an employee witness, followed by panel 2, government agency witnesses, and panel 2 will include testimony presented on behalf of the executive. And then we'll ask questions of the agencies to evaluate possible ways to improve our policies and procedures. And now I'd like to recognize any of my colleagues that are on. I actually have a colleague who is here on the dais with me, and I will turn to Council Member
Parker.
I was going to say from the great, almost said the great state of Ward 5. Councilmember Zachary Parker, a great colleague, and we are from the same part of the city, so that's why it's important. Ray for Ward 5. All right, Councilmember.
Thank you, Chair Barnes, for both that thorough overview of the mayor's order, but also following up, as you said you would, earlier this summer. And so this roundtable is necessary and much appreciated. I'll be brief and just saying that no employee of the District of Columbia should feel unsafe in their workplace No one who contracts with the District of Columbia should feel unsafe around district employees. No one should be subjected to sexual harassment by someone in a position of authority and influence. And no one who steps forward to report harassment should fear retaliation. The mayor's issuance of this order represents an important step towards addressing the harm that was done by the former chief of staff. The changes this policy implements are long overdue, and I welcome them. Changing policy is not the only answer, and I continue to support the full investigation of the former chief of staff's conduct, which represented unlawful and potentially criminal behavior. As folks know, the council demanded and funded an independent investigation. While that has taken longer to get off the ground than we had hoped for, I'm glad that today's roundtable is happening and that the mayor's order addresses more broadly sexual harassment. Today, I look forward to diving into some of the details of the new policy to ensure that it implements robust protections against sexual harassment and retaliation. And so with that, Chair Bonds, I will turn it back over, but I will just also add that I'm a bit disappointed to hear that we didn't hear back from DC Public Schools. And I think it's worth the public noting that there's a trend happening across committees where DC Public Schools has just decided that they are not, and the leadership of DC Public Schools has decided that they are not going to abide by the council's request for hearings and or for information and or the law by way of submitting contracts in a timely manner. And so this is yet another data point that is increasingly concerning to me. But with that, Chairperson, I turn it back over to you. Thank you.
Thank you very much, Councilmember Parker. We just want to also note for the record, there is a competing hearing today, and it does in fact deal with the budgets of our public school system. So it could very well be that that is where the public schools representatives are at this moment.
Sure,
it began at the same time.
Quick question.
Yes.
It is my understanding that hearing starts at 2:00 p.m.
Okay.
Is that right?
All right. Thank you very much. All right.
Thank you, Chair.
All righty. Thank you. Now we will hear from our public witnesses, panel one, I believe, Ann Wilcock and Wayne Enrich from ASME. Okay, they're in the Zoom room. All right, okay. We'll bring you on.
Hello.
Oh, Ms. Wilcock, thank you. You can begin when you're ready.
Good afternoon. I wanted to talk briefly about what's actually happening with our independent agencies. The independent agencies seem to have their own set of rules and regulations. The bullying and harassment that occurs in a lot of the agencies that don't have enough oversight. We have prolonged investigations that carry on, which results in victims being subjected to retaliation for extended periods of time while the investigations are going on. There definitely needs to be some type of limit placed on this. There needs to be more enforcement of the rules. And the investigations, in my particular situation, without giving more detail, too much detail rather, I believe that we need the agencies to have the third parties conduct the investigations, and those investigations should be turned over to a third party agency and not the agency for which the allegations are against or the staff within that agency. Because in my experience, the reports are coming back with not the findings of the third party, but the findings of the agency after the investigations are altered. And again, there definitely needs to be more protection for victims, more accountability, and more transparency. And one key thing is when a victim does file a harassment claim or bullying claim, if a lawsuit follows, then they're left to fend for themselves because the city won't get involved because of the pending litigation. And the agencies know this. And so this victim is left again being a victim again, not just to the bullies, but to the system that's in place, that's designed, that's supposed to protect them. So there are a lot of flaws and loopholes in the policies that need addressing so that victims feel comfortable coming forward and they are not, or they don't continue to be victimized. So I think there's a lot of things that need to be addressed with the loopholes in the protection of victims, and even the agency getting involved, or other agencies, a third-party agency getting involved to review the investigative reports after the third party conducts them. And that's it.
Thank you very much for your testimony. I just wanted to ask you rather quickly if you are familiar with the mayor's new order 2023-131, and with the council's policy and or the DC courts personnel policy.
I am not familiar with the mayor's new policy. I have not got a chance to read it. Actually, I did not know that there was a new policy. I am familiar with the vast majority of DC government and the Superior Court's policies and rules.
All right. And have you had a chance to look at the DC Council policy?
I believe I have looked at the policy. I looked at the policy in relation to, actually, I think I got to it through chapter 16, I believe. I'm not quite sure.
All right. It is very lengthy. We think we were very thorough, but now with the mayor's revised order, we're going to do some comparison. The goal is, of course, eventually to have a uniform policy as much as possible throughout the government.
Yes, and that would be great, Council Member Bonds, because and I hope the uniformity also includes our independent agencies. Our independent agencies are some of our independent agencies take that independency to a whole nother level, and there seems to be no accountability whatsoever. And each time something occurs, they lean upon that. We're an independent agency and we don't follow the district government. There should be some things that are straight across the board to eliminate the disparities in treatments between one agency and another agency, because some people will leave an independent agency, and that's exactly what I plan on doing, because there isn't enough oversight, and these agencies are just doing whatever it is they want to do, and it's just really unfair, and victims are already experiencing trauma from being victimized, and then you experience additional trauma from not receiving the assistance or the protection that the policies lay out. So that's very huge, and I think there needs to be a lot more enforcement and oversight of these policies.
All right. Well, thank you very much, and we will follow up with you on a couple of points that you're making. We will endeavor, this committee will endeavor to get any of the independent agencies' policies so that we can include them in the record. And of course, when we have the Office of Human Rights before us, we will inquire as to whether or not they are expecting to get the annual reports from these agencies as well. So
all right, thank you again. Thank you.
Thank you. Next, we'll hear from Mr. Anuch. He is representing, in fact, he is the executive director for the ASME union. Please go ahead when you're ready, sir.
Good afternoon. I am Wayne Enoch, Executive Director of ASME Council 20. I've been an employee of the government of the District of Columbia for 30 years. I'm also a district resident. Council 20 is the collective bargaining unit of over 17,000 employees. We have bargaining units in DC, federal, Arlington County, and Alexandria city governments, as well as the Washington Convention Center, Howard University, and American Medical Response. I've held various positions within ASME, affording me the opportunity to meet with a large number of members with varying concerns. It is highly commendable that this council is addressing sexual harassment within DC government. I am further concerned about all forms of harassment, bullying, and discrimination that exist in DC government. These inappropriate behaviors create a toxic and hostile work environment. The overall system and culture are a reflection of why this roundtable is necessary. A few years ago, in a previous testimony to DC Council, I testified about a culture where members were in term or not to exceed positions, and they were often reminded of their status. Because of the council's oversight, the agency had to answer why employees were in term statuses for up to 15 years. Ultimately, the agency changed those dozens of employees to permanent. It goes without saying that council oversight is highly impactful. Harassment and discrimination in the DC government affords managers the capability to retaliate against accusers and reporters. Often that is done in a performance evaluation. It is extremely difficult for an employee to prove retaliation in an evaluation review. I'm aware of individuals who recently made reports of discrimination and feel their evaluations were impacted. I'm glad to see the mayor's recent order includes independent agencies such as libraries, OCFO, and OAG. Quite often, these agencies make their own policies and procedures that are not adequate. Therefore, it is imperative that the council further reviews the policies of independent agencies. They should be encouraged to comply with the timeliness noted in the mayor's order. For example, although it is a well-written policy, the most recent OAG policy does not include timelines. The mayor's orders require investigations to be completed within 60 days. In my opinion, that affords sufficient time to resolve issues and take actions as needed. I had a recent experience with a hostile work environment case at an independent agency that took more than 60 days for the victim to receive a closeout letter. Although it was not sexual harassment, the report was made on June 28th and closed out on October 30th. During the entire time, the manager was allowed to remain on active duty with nothing done to protect the impacted employees, despite multiple witnesses to the incidents and multiple reports. In contrast, when a line worker had a complaint made against her, she was ordered to full telework during the investigation. Ultimately, the closeout letters indicated the manager had no intent to subject you or anyone to discrimination. I reviewed the mayor's 2023 order, and I find it addresses many of the issues that are needed in sexual harassment policy. However, the concern that I have is that it allows victims to report harassment to various entities. Specifically, I am concerned about the reports made to supervisors. In the policy, it provides procedures for a process for the sexual harassment officer to investigate reports. However, I did not see what happens when an employee discloses harassment to a manager. In contrast, the September 23 OAG policy gives direction for what a manager should do if someone discloses an incident. In the mayor's order, I did not see a repercussion if a supervisor does not take action. Regarding oversight of these cases, as of November 9th, 2023, the most recent Office of Human Rights report is not available online. The most recent one available online is for fiscal year 2021. My assumption is that reporting is done and presented to City Council. However, it should be on the agency's website for the public to view. These incidents are very relevant to public perception of how the district operates. Overall, I feel the order is impactful if implemented and, more importantly, enforced. Resources should be in place to ensure that it's not just an order. Quite often, it has been my experience that the EEO counselor lists are outdated and the individuals listed do not return calls, or they were not able to assume further cases, causing impacted individuals to become frustrated and feeling hopeless. Having the order is great, but systematic culture and change is necessary. If these behaviors are not addressed, the district, just like any other employer, runs the risk of losing talented employees while retaining toxic employees. That is not what we as district residents want. Thank you for your time.
Thank you very much for your testimony. Just have a few questions for you. I think your voice was sort of dropping when you were going through maybe two points of where you feel the most recent mayor's order it doesn't address the kinds of issues. Could you just repeat those, please?
As the mayor's order shows what happens, what the process is for the sexual harassment officers, how they conduct an interview and how they review a case. But if someone makes a report to a supervisor, there's no instructions on how that process goes that I saw in the policy. It was very specific to that sexual harassment officer, what they are to do. And I would want to make sure that a supervisor knew that they need to do some type of reporting or investigation on the allegations that are being made.
Thank you very much. I just wanted to make sure we had that. And I want to remind all of our witnesses, please assure us we will have your written testimony. That's very important that we put it in the record. So thank you. Thank you.
Yes, ma'am.
Thank you for your testimony. Mr. Unruh, you also mentioned that I believe you said you wanted the mayor's order on the agency website. Is that correct?
No, I did not say that. I mentioned
Okay,
the
right.
Office of Human Rights and not having the more recent reports on their website. The most recent one I saw was 2021.
All right, well, we have a law that stipulates that reports will go to the Office of Human Rights. And so we'll hear from the director on that as to whether or not there's a comfort that these reports are coming in or going to come in. So thank you very much for your testimony today.
Thank you.
Now we will hear from our government agency witnesses on our panel 2, and I'll call up the first 3 maybe. Ms. Hinkine, who is the Office of Human Rights, Jeb Ross, the Office of Risk Management, and Christine Davis, the Department of Public Works. And we can add Mr. Reeves Gavilan, our public libraries. We have 4 seats. Thank you. And thank you all so much for joining us today. We really want to get to on this. I'll now swear you in if you raise your right hand. Do you swear and affirm that your testimony and any statements that you make today be truthful and complete? Thank you. All right. We have a series of questions. I know that you're not presenting testimony per se, So we'll get right to the questions and then we'll come back and get the administration testimony. So just give me a moment to find all of this. Okay. Would each of you please discuss your agency's FTE count, your operations, your work posture on and off in the office, off-site, and how the staff will abide by the new mayor's order? And we can start with you, Ms. Gavlin.
So DC Public Library has anywhere from 550 to 600 and change FTE. I don't have the exact number in front of me, but happy to get that for you. Our current work posture, is that specific to telework? Or I'm not sure what you mean by.
Well, work posture, are all of your employees located in one location?
I see, okay. We've got, our staff is spread out among our 26 libraries, most of whom are at our central administrative library, the MLK library, on 9th and G. We also have a couple of staff working periodically at the DC jail.
All right. And how will you translate or get this information, the mayor's order, to your staff?
Well, we've already begun, and certainly we were supportive of the previous mayor's order in 2017. We established a sexual harassment officer and an alternate sexual harassment officer. We've done that again to comply with the 2023 order. So we have established a show and an alternate show. We've got our information, including the new order, including the contact information on the library's intranet site, its SharePoint site. We are very supportive of the stipulations in the new order, including the training that's required for every new staff member that comes into the library as part of the onboarding process. They are provided this information. And I'm also very excited that we're moving from a 2-year posture to a 1-year posture. I think that level of inculcation can only help remind staff that even, off-color jokes are things that should be avoided, and they're not appreciated, and I'm hoping that it would avoid, exacerbating issues of harassment.
Okay. Ms. Davis, want to tell us a little bit about Public Works?
Good afternoon.
Good afternoon.
DPW has approximately 1,500 FTEs. The numbers go slightly up and down based upon the season. We have seasonal hiring. In fact, we're in one of our seasonal events, the leaf season right now. Our operations are 24 hours a day, 7 days a week. We have 3 primary business units. That would be the Solid Waste Management Administration, our Parking Enforcement Management Administration, and our Fleet Management Administration. They're all housed in various locations across the city, but the primary locations for solid waste is at 1725 15th Street Northeast, as is for parking enforcement. And then our fleet office, they're on one big campus, is at 1833 15th Street. Our work posture, as I said, we're 24 hours, 7 days a week. Depending upon your job, your tour of duty is established. You're either working, you could possibly work from 6 to 2:30, Monday through Friday, as HR, until we've shared that information with all staff. We will also be providing hard copies of the policy and getting acknowledgements from all of the employees over the next couple of weeks.
Thank you both. And I know you were initially wondering, why are we being called to this kind of hearing? Well, when we looked at the past 5 years, you had some high numbers. And so that's why we wanted to make sure that we heard from agencies that had high numbers of claims that were filed. So that's the understanding. You probably know better than I, that most of the claims were more verbal than actual touching. In fact, most of the claims that have been filed, across the government, I think 277 were more verbal. The talk that seems to do a lot of damage. And so we just wanted to put on record that these are the organizations that do have a large number of claims, and it most likely is, from the data we received, verbal accounts of harassment. So I just wanted that to go on the record. Now we'll turn to risk management. How are you doing?
Good afternoon, Chair. The Office of Risk Management has an FTE count of around 89 FTEs. Our operations are mainly at the Marion Berry building in 3 locations, but all very close together in office settings. We do have a few employees who go out and investigate health and safety concerns in buildings to make sure buildings are safe. As it relates to the particular order, we have always had a show at our agency, and we appointed another new show with our new HR director. We will be going over the policy with all of our employees. We talked about ensuring that we are treating everyone respectfully and appropriately on a regular occurrence. We look forward to enforcing the new rules. We were always following through in the prior. I can say that our agency has not had any allegations to my knowledge. So the Office of Risk Management will continue to enforce this great new policy, ensuring that we are protecting all of our employees.
Okay. And for the 3 of you, and looking at the mayor's new order, are there any glitches, any areas where you think we should include in the policy that may be missing, or do you see it being very holistic in its approach of addressing sexual harassment?
I'm happy to answer.
All right, all right.
I believe that the policy is extremely thorough. I think the mayor is leading and ensuring that we take this very seriously as a government body. I believe that the policy is very exhaustive. I believe that there's additional things that are being done from the prior order to ensure that we are, upholding the mayor's vision to protect all employees, something that we've always wanted to do and always will continue to do.
I agree. I believe the policy is forward-thinking. It builds upon the original policy. It gives the agency additional tools in addressing sexual harassment complaints and ensuring that we provide a harassment-free workplace. So I believe it is key to us achieving the goal of a harassment-free workplace.
One of the questions that ASME just posed for us is what happens when an employee approaches their supervisor, the supervisor receives the complaint, and apparently in his looking at the mayor's order, the 2023 order, he feels that there's no description that says what happens once the supervisor gets the complaint. Now, I know in the old order, it was clear that there was, as Mr. Ross mentioned, the show, or, the person who's responsible for administering, helping the claimant, understand what the circumstances are and to move forward with the interviews, and finally the disposition on the case. So do you feel that ASME's concern is one that we need to address and there may be missing from the mayor's order?
Chairperson, I can take that question. The order actually does address that issue. If you look at section D, letter D, 1E, it does explain. I'm sorry. Oh, the page number is 11. It does say that if a complaint is reported to someone other than the show, the person receiving the complaint must notify the agency show unless there's a conflict. If there's a conflict, then it has to be reported to the general counsel. So there is a procedure contemplated for when it is other than the show.
Thank you very much. I wanted to make sure that we get as many questions answered through this hearing as possible, because this is about our government. It's about our employees. This is not about our neighbors. This is about, well, neighbors, yes, if we sit near each other in the workplace or something like that, but not our neighbors that are not inside our government. So thank you for that.
Councilmember, may I
Yes.
add that
Yes,
in the
please.
training for the shows and the sexual harassment training all employees receive, supervisors are instructed to share the information with the show.
Okay, they are instructed.
Yes, they are.
All right, excellent, excellent, okay. The Office of Human Rights, we bring all of the information to you ultimately, but you also are a participating office. So tell us what, discuss your agency, please.
Sure. Good afternoon, Chairperson. So approximately, I can say that our agency has about 75 FTEs. Our work office is divided into 2 locations, but mainly at the Marion Barry building. In terms of the dissemination of the policy and implementation of the mayor's order, we have already begun disseminating the order. We will do a training, as a matter of fact, on Thursday at our staff meeting to go over it. We've also already shared and circulated our designations of the shows. And so we are on target to meet all of the various deadlines established through the mayor's order.
All right, well, let's talk just a quick minute about these deadlines. I noticed that there's a deadline of I think it's the 17th of November. Then there's a deadline of the 12th of December. And of course, the council had a deadline for reports to come into you, to your office. And it seems like there's not enough time. Tell me what you think about that and how we can address this matter, because I think we have to address it. That's just my thought.
Thank you, Chairperson. There are a number of deadlines, I'll admit, swimming in my head, and as well as our agency leadership, but we are working diligently to meet all of the deadlines. And in terms of, if you're referring to the Sexual Harassment Data Collection Act,
Yes.
we are on par to get the data. The deadline ended yesterday. And so we're in the process of ensuring that every agency has reported their information. And then we will diligently follow up if there are agencies that are missing from our list. But we will very much appreciate your flexibility for the report if that can be an exception that can be made, for sure.
Thank you. Music to our ears. When I saw that, I was like, ah. So thank you very much. I think it's important that if we want everyone to take the policy seriously, we really have to make sure that it is in the format where people can comply. And so in that spirit, I wanted to ask you about the deadline. So thank you very much for that. I appreciate it. I have a few questions here that are really to help us understand how to utilize the mayor's order and to bring understanding to all of our employees. So what are some of the significant changes in human behavior that you have witnessed in recent years that can impact the workplace? I mean, some things that you think we're doing differently. For instance, one agency was telling me that years ago in the government, we decided that people would not have offices, but they would sit pretty close to each other without a partition. And they felt very strongly that meant that they became more familiar with each other and whatever an individual might be dealing with or handling a call from a child or whatever, they get into everyone's business or each other's business. Do you see that? Have you any encounters like that from any of your employees? I know you all have individual offices, cubicles with mirrors and windows, I guess. I don't know.
Maybe I'll share, Chair Bonds. Among our 600 staff, the vast majority of whom work in freely accessible public libraries. Last fiscal year, we had 3 million visits to our libraries. So there are lots of people interacting, public and staff, staff and staff. That has not changed. I think in some ways the pandemic has raised everyone's anxiety a little bit based on just world events, I think, and local events. So I think there's just a bit more edge among a lot of our staff. But that said, I don't see anything that would influence the number of instances of allegations of sexual harassment changing. That's from the perspective of me at the library.
Chair
Chris?
Bonds, I would agree with my staff that the space is the same. It really hasn't altered. We continue to provide great service to our constituents, and I don't really see any distinctions from anything in the past based on the way that we work together. I don't see any concerns.
Okay, I really wanted to ask, the library, which is very public, you're in a more office environment, and we know you're out and around, all over the place. So we understand that. Just want to get that kind of feeling on the record if we could. I have a lot of questions here, but you really answered quite a few already, so I thank you for that. One of the ideas that we had when we talked a little bit in the working group in September was perhaps we needed to have a way to post periodically, maybe even through the computer, pop-up that is the list of do's and don'ts, or the don'ts, like don't do this or you could be, and then the consequences might be thus and so. And it also, we thought that we might look at that as maybe signage that's posted, within the office. What do you think about those ideas? Any thoughts whatsoever?
DPW already communicates in that manner. We have a system, a televised system, where we have televisions throughout our facilities, and they scroll information that we're providing to our employees, be it our weekly newsletter, reminders about training, good news stories, commendations, and things of that nature. So we provide that information in that manner, in addition to posting in lunchrooms or break rooms, ensuring that the shows are listed, reminders of upcoming sexual harassment training or any type of training that we are offering. And then the third manner in which we communicate is during our roll calls. Every day, our supervisors meet with our employees before they're deployed to their work site. And that's an opportunity for the supervisor to cover important topics, safety issues, sexual harassment issues, things to remind our employees of before they begin their tour.
Thank you. Anyone else? No? All right. Okay. Can you please discuss the e-risk system for centralized reporting? How do you see that working? And that is on page 22 of the mayor's order, if you're familiar with it.
Chair Bonds, yeah, that is just a system to manage tort claims generally. and other claims that come in for the district. So when there's an actual formal filing, that's where those claims are put into. Generally, when it turns to litigation, it moves over to the Office of Attorney General, and then they handle it through their system.
Okay, I guess I'm looking at page 22, and I see item D, but it's related to the records, as you said, but it also indicates that each year an agency shall track the number of complaints. That starts on page 21. So how do you feel about that? I mean, is that an easy system to use for tracking complaints?
What I can say, Chair, is definitively as it relates to OHR, they are definitely collecting that data now, and that information will be easily tracked and through the OHR process, through the records, the Data Recording Act that the council had put forward. So I know that all that information will be there, and if there are formal claims filed, or if there's formal lawsuits filed, then there will be places for that information will be tracked in an appropriate way.
So are you informing me that an agency may have a complaint? The agency does its due diligence. The information is then transmitted. I think if you're an operating agency, it goes to the MOC. The MOC in turn makes sure that the Office of Human Rights may have a copy, or is it stays with the MOC?
No, we don't get a copy of the complaint. The only information we would get is either through the Sexual Harassment Data Collection Act, as you know, is new for FY24. And then, of course, any official complaints, legal complaints that are filed with our office. Those are the only two points of information or actual complaints that we would get.
So complaints that are filed with, let's say, the Office of Human Rights, because a government employee can go anywhere almost to any agency where they feel comfortable. They do not have to go to their supervisor. So those things that are filed with you stay with you, or are you also, as the Office of Human Rights, required to send a copy to the MOC?
No, so I think this is a good juncture to discuss the difference between the mayor's order and the DC Human Rights Act, which the Office of Human Rights enforces. So the mayor's order is an employer's policy on what policies and procedures agencies should follow, including an internal investigation by the agencies that are involved. But so that's mainly an employer policy. But with the Office of Human Rights, we adjudicate claims, legal claims that come to our office. So an employee has a right to file a claim either at OHR or in court. Those are the two locations, or the EEOC, the Federal Commission, Equal Employment Opportunity Commission. So those are legal remedies, which is very different from an employer policy like the mayor's order governing government agencies. So I hope that clarified a little bit. So I wouldn't get a report that goes to MOLC, because that is an internal employer investigation into what's happened. It's not a legal investigation. It's again, an employer review of what's happened, rather than a legal adjudication of a matter that would have been brought to OHR.
Okay, I have two questions then. So if I want to make a claim and I decide I want to go to your office, I come to your office, can I make the claim there, or do you direct me somewhere else?
No, so you absolutely have a right to file a claim at the Office of Human Rights.
All right.
Yeah. And that's where we would be able to issue a legal order to provide remedies for the victims of discrimination, including sexual harassment victims.
All right. Well, this is the big question then. If you can provide me with instant gratification, so to speak, then why should I send it to MOC? Why should I even go to another agency where they have to go through MOC?
So again, I think it's important to take note of the differences. So the procedures outlined under the mayor's order and Molt's involvement is to afford agencies and the district government as a whole an opportunity to provide immediate remedies. OHR can't provide immediate remedies because we have to do a legal investigation and a legal review of our findings. And so our process is going to take a little longer. The mayor's order really outlines the detailed ways in which an agency facing, an issue of inappropriate workplace misconduct can take an action, a swift action. And that's what's so great about this order.
All right. So the mayor's order will provide swift action with the proviso that the complainant will go to one of the agencies. But if they happen to come to your shop, the Office of Human Rights, it may take longer and it will get into legal process.
Right. So the difference is that the Office of Human Rights and courts, right, these two places, we can make a legal requirement of a respondent like a government agency, right? But an internal investigation there's not a legal weight to it, if you will. Whereas Office of Human Rights can make that legal order for a certain remedy to take place.
Okay, so let's say I file with public library and I want relief. What can public library give me in the way of relief?
Sure.
Under the mayor's order.
Sure, and I could let the director respond, but I think an example, and it's set out in the mayor's order as well, that an example that an agency can take immediately is perhaps a reassignment, right, and separation of duties amongst the two individuals that are involved in a given situation, whereas OHR doesn't have the immediate authority anyway, to order such remedial solution, if you will. So there can be the sort of temporary resolution that can be very effective that agencies like DCPL, for instance, can deploy.
Okay, I'm gonna make it a little tougher. So I am romantically involved in this relationship, and I feel like the supervisor is putting his or her foot down and causing my romantic partner to really resist the request that he moved to another library. Is that something that can happen?
Can an employee resist following the order?
Yes, remember, it's just an order. It's not a legal remedy. That's what I just learned.
I think it would still be enforceable by the agency, that if they deem that there's a conflict, and I mean, we can move staff for any reason that we want, and that would be one reason that we would. So
you mean any good reason, right?
any good reason,
yes.
yeah.
Thank you.
Yeah.
Thank you.
And I would just add that perhaps Director Hall may be able to better answer this question, but that, these processes are put in place to allow for the situation to be resolved without impacting the employees at issue.
All right, I appreciate that. I thank you all so much for your comments. I do want to just, if I could, just ask a couple of questions regarding the numbers that we were looking at. Just wanted to try and clear those up. Got it. Okay. I wanted to ask of the Office of Risk Management, which of the 4 divisions within your office are your sexual harassment settlements handled? Workman's comp, risk prevention and safety, risk insurance, or tort liability?
If we get a claim, Chair, it would go to our tort liability division.
And they would do the resolution.
Yes, they work to resolve any claims against the city. However, more often than not, the matters turn into litigation. And because we can't do fact finding, in the same way that a lawyer can. And in those instances, it goes to the Attorney General's office.
All right. Can you discuss the process and the timeline for resolving a sexual harassment case, including if you're going to issue a settlement and the distribution of the settlement?
Chair, I can say that each and every claim is different, and timing is dependent upon determining the facts. But I can tell you with certainty, the vast majority of any matter, we don't get very many, because they turn into automatic employment lawsuits generally. They are handled at the Attorney General's office for the most part. But if it were to happen, it'll be an expeditious inquiry with the general counsels of the agencies.
So then if there is a claim, and you are going to forward it to the Attorney General's office, and what is the timeline from when you receive the claim to you turn it over to the Attorney General's office?
As soon as a matter is filed in Superior Court, formal litigation, then all the information is transferred within days, if not same day.
Okay, thank you. And where would the funds for this settlement come from? What bucket?
It depends on the specifics of the matter. The funds can come from agency budgets, or it could potentially come from the settlement and judgment fund. It just depends on the particular circumstances.
So with the mayor's new order, do you anticipate any uptick in claims and settlements?
I don't believe so, Chair. I believe that ultimately agencies, I think this mayor's order is fantastic in that it's continuing to push forward. It's continuing to ask agencies to train, to instruct, and to require people to report allegations, but also to let people know that the mayor and the district takes this seriously and that we're going to ensure that we're pursuing bad actors. So from that perspective and protecting our employees. So I think that it will continue to push forward in hopefully mitigating these circumstances.
Okay. In your office, do you have attorneys there, you're an attorney, but I mean, you have attorneys like a general counsel, correct? And that's the counterpart or the individual that would work directly with the Office of Attorney General. Is that?
Our general counsel staff do work with the Attorney General, yes.
Okay.
When asked and when brought in, for sure.
Okay, thank you. Public Works. I knew I had a chapter for each. Not a chapter, just a page, just a page. So how do you foresee the new order impacting the current interaction between off-site employees and the public?
I don't foresee any changes in the interaction between our employees and the general public. They are currently expected to carry themselves in a professional manner and deliver the services and comply with the mayor's previous policy. This new policy builds on the old. It just furthers their obligation to perform and conduct themselves in an appropriate manner in the workplace as well as offsite.
I have a question for the library, but it seems pretty deep to me too. But it says, how do you think any changes in human interactions may impact sexual harassment and workplace culture?
Well, again, I think inculcating the measures in this order, the respect that we have to have for one another, what is not allowed, what is inappropriate, even if you think it is rather benign. Inculcating that twice a year through training, more often than that through signage and website and other things, can only result in good things in terms of how we interact with one another. Separately, the library has been working on a number of purpose and core values initiatives, creating a culture of respect, having less to do with sexual harassment, but more of just how people interact with each other, how we welcome members of the public who are coming in with questions and problems. So I think that this only adds to the arsenal of good work that we have to encourage good behavior and respect among our staff, and hopefully through osmosis to our public as well.
All right, well, I won't ask you this, but you can think about it. Do you envision our libraries, how do you envision them functioning in the next 10 years?
Is this another hearing, or do we want to?
It's not really about this. It's about just thinking about our workforce and thinking about how we'll interact with each other in the offices. So it's really kind of down the road. It's not like here and now.
Well, I'll tell you after the FY24 budget is adopted, and I'll tell you what we'll be looking like for
Okay.
the next few years.
All right, thank you. All right, thank you very much. And Ms. Cotton, if you will remain, and I'll bring up the other teams. Thank you all very, very much for your input
Thank you.
today. And we will now hear from Ms. Rachel Noteware from the Office of Legal Counsel. And Mr. Charles Hall, who I think brought an army with him. All right, thank you very much. And for the record, I'll ask you pretty much the same questions. Your agency's FTE count, the operations, offsite in the office, and how do you see your staff abiding by the mayor's new order? We'll start with you, Ms.
Do you need to swear us in,
Oh.
Chair? Okay.
Yeah, you're right. He just said so.
Oh.
All right. If you raise your right hand, we will swear you in. Okay. Do you swear or affirm that the information that you shared with us today to be truthful and complete?
Yes, I do.
Thank you. All right.
All
You
right.
can begin when you,
Sure.
all right.
So
You
I'm
have
Rachel No-
testimony?
Yes. Just,
Okay.
I have I can give you briefly the FTEs
The
and the
statement would be fine. Yes,
Sure.
go right ahead.
Okay, great. So I'm Rachel Noteware. I'm an associate director in the Mayor's Office of Legal Counsel. We have about 8 FTEs who are primarily responsible for providing legal advice and support to the mayor and her senior staff, including the deputy mayors, agency directors at the subordinate agencies. And we do this directly and through oversight of the general counsels. Our duties typically include interfacing with OAG, working closely with ORM on reducing legal and financial liabilities for the district, resolving interagency disputes on behalf of the mayor, overseeing representation of the agencies and investigative matters before the federal government and council, and supervising outside counsel in matters where OAG is recused, and coordinating the hiring, compensation, and training of agency counsel. So in terms, we also handle FOIA, adjudicative appeals, and the legal review of donations in the district. But in terms of the sexual harassment process, MOLC's role is as a member of the Sexual Harassment Task Force. We help develop training materials and review regulations to implement policies outlined in the mayor's order, as well as we act as a clearinghouse for receiving both the agency, when they have a notice of a sexual harassment complaint, they notify MOLC, and when the agency drafts their findings and conclusions, they send a copy of that to MOLC as well. I can answer other questions about the new order and our role in that as well, if you'd like.
All right, thank you. Mr. Hall, I believe you have the official executive testimony. So if any of the previous panel had testimony that you wanted to present, I was informed that we only had one set of testimony, so I apologize, but I certainly would like to get your information, your testimony for the record. So Ms. Davis, if you have anything, or Mr. Ross, if you have a statement, we can include it in the record. So and of course, Mr. Gablin, if we have, we'll include it in the record. Mr. Hall, please, I'm sorry.
You want me to proceed with the testimony?
Yes, proceed with the testimony.
Excellent. Good afternoon, Chairperson Bonds, members and staff of the Committee on the Executive Administration and Labor. I'm Charles Hall, and I serve as the Director of the DC Department of Human Resources. I've been joined, as you've seen, by district government agency directors and general counsels who have been available to respond to questions that you've had. I want to thank you for the opportunity to testify on Mayor Bowser's commitment to prevent and remediate sexual harassment in the workplace. At the heart of every organization is its people. In the district, over 37,000 employees provide exemplary services daily to residents, customers, and visitors. The employees are guided by Mayor Bowser's core values and guiding principles. We are stewards for the District of Columbia. We are committed to our residents. We are accountable, and we are respectful, responsive, and accessible. Through these values, the district clearly articulates how employees should treat our colleagues and those we serve. On October 31st, Mayor Bowser reaffirmed her pledge and stance against sexual harassment by issuing Mayor's Order 2023-131. The new Mayor's Order strengthens the district's existing sexual harassment policies and makes important clarifications. The importance of a comprehensive sexual harassment policy cannot be overstated. The Mayor's Order serves as a crucial foundation for creating a safe, inclusive, and respectful workplace, and it sends a clear message that the district government will not tolerate any form of sexual harassment. I will begin my testimony by highlighting the key points from the Mayor's Order. The Mayor's Order clarifies, consistent with the Human Rights Enhancement Amendment Act of 2022, the definition of sexual harassment to include any conduct of a sexual nature that constitutes harassment, which is conduct that is direct or indirect, verbal or nonverbal, that unreasonably alters an individual's terms, conditions, or privileges of employment, or has the purpose or effect of creating an intimidating, hostile, or offensive work environment. Sexual harassment also includes quid pro quo sexual harassment, which are sexual advances, requests for sexual favors, or other conduct of a sexual nature where submission to the conduct is made either explicitly or implicitly a term or condition of employment, or where submission to or rejection of the conduct is used as the basis for an employment decision affecting the individual's employment. Additionally, the Mayor's Order, quoting the expanded definition of sexual harassment, provides that actions do not need to be severe or pervasive, nor do several incidents need to occur to constitute a sexual harassment. The expanded definition means employees are empowered to report even singular or small incidents of a sexual nature. Reiterating examples provided in the previous order, the order helps underscore to employees the range of behavior that can contribute to or constitute workplace sexual harassment or an intimidating, hostile, or offensive work environment, include but are not limited to sexually offensive comments or off-color language, jokes, or innuendo, sexting, display of sexual organs, and other sexual acts. Our employees deserve a work environment that is professional, fair, and safe. Conflicts of interest should be mitigated, and promotions and opportunities should be based only on merit and performance. To help ensure the professional integrity of the workplace, the mayor's order explicitly prohibits certain conduct and intra-office relationships between employees. It is now prohibited for supervisors and those they supervise to engage in a dating, sexual, or romantic relationship within the chain of command, whether the supervision is direct or indirect. It is now prohibited for employees to engage in dating, sexual, or romantic relationships with trainees, recruits, and interns. And employees shall not engage in a relationship that would be prohibited by professional codes, such as doctor-patient, lawyer-client, and social worker-client relationships. Current employees are participating in a prohibited, who are currently participating in a prohibited relationship must disclose the relationship to their designated agency official by December 8th, 2023. To resolve any conflicts posed by such relationships, the district may recommend remedies such as shifting the reporting structure or providing the employees with reasonable time to find a new position. If a resolution cannot be reached, the employees in a prohibited dating, romantic, or sexual relationship may request a waiver for the relationship. New relationships are prohibited, and employees should resolve any chain of command prohibitions before beginning any new dating, romantic, or sexual relationships. In addition, the mayor's order clearly states that sexual activity of any kind during work hours, regardless of location, is strictly prohibited. Violations of the mayor's order shall be subject to appropriate personnel action up to and including termination. As stewards of the district and its values, employees are obligated to treat everyone with whom they interact with respect. The mayor's order outlines key employee responsibilities as we all collectively work to maintain a safe workplace. Employees must refrain from engaging in behavior that constitutes sexually harassing conduct, refrain from initiating or participating in a prohibited dating, romantic, or sexual relationship, affirm their agreement to comply with the mayor's order, complete annual sexual harassment training, cooperate fully in any inquiry or investigation into an alleged violation of the district's sexual harassment policy as defined by the mayor's order, and refrain from any behavior that may call into question the impartial and harassment-free provisions of services to constituents, agency clients, or customers, contractors, or grantees. Although the district is working tirelessly to prevent sexual harassment from occurring in the workplace, we want to ensure all employees understand how they can report incidents of sexual harassment should they occur. Employees who are victims or who have witnessed inappropriate conduct should report it. Employees can report misconduct to their agency sexual harassment officer or a show within another agency, their supervisor, the supervisor of the employee engaging in inappropriate conduct, or their agency general counsel. To ensure all employees know who their show is, each agency is required to post the contact information of the shows in a highly visible area, such as break rooms. A list of all shows is also available on DCHR's website, or employees can receive the list by emailing dchr.show@dc.gov. In addition to the reporting process outlined in the mayor's order, employees may also file complaints relating to sexual harassment with the Office of Human Rights, the Equal Employment Opportunity Commission, and other grievance procedure available to them, including those under an applicable collective bargaining agreement, the Board of Ethics and Government Accountability, or any other applicable process. The mayor's order outlines the investigation process when reports are filed. Each agency is required to designate a primary and alternate show who is responsible for conducting the sexual harassment investigations, including collecting and weighing evidence, providing their impressions of the credibility of witnesses, and corroborating, substantiating, and refuting factual allegations. Absent unusual circumstances, agencies have 60 days to complete a sexual harassment investigation. Investigation reports are kept confidential to the greatest extent possible. To ensure they are effectively trained, shows complete annual training provided by DCHR and the Office of Human Rights. In addition, shows may participate in several refresher training opportunities throughout the year. The mayor's order provides more protection and potential remedy to those who may experience harassment from grantees and contractors. District government employees or customers, clients, and beneficiaries of the services provided by contractors and grantees may file a complaint that trigger sexual harassment investigations and remedial actions. Remedial actions may include requiring the contractor or the grantee to use alternate personnel to provide services and other remedies available under the contract or grant agreement up to and including contract or grant termination or non-renewal of the grant or contract. Likewise, contractors, grantees, and customers of agencies may report allegations of inappropriate conduct to the show of the relevant agency or any other agency, the relevant agency's general counsel, the supervisor of the employee who engaged in the inappropriate conduct, or their grant or contract administrator. To ensure the district's sexual harassment policy meets the needs of the ever-changing workforce, the mayor's order also charges the Sexual Harassment Task Force, an internal working group comprised of representatives of the Office of Human Rights, the Mayor's Office of General Counsel, the Department of Human Resources, the Assistant City Administrator, and the Mayor's Office of Legal Counsel with reviewing training, employee guidance and policies, and recommending any needed changes to further prevent and remediate sexual harassment in the workplace. Any allegation of sexual harassment is disturbing and can harm the morale and integrity of a workplace. I believe the vast majority of district government employees abide by the district's core values and do their best each day to maintain a respectful and welcoming workplace. As a preventative and proactive measure, the mayor's order provides detailed and clear employee guidance on conduct that is inappropriate, provides a process for reporting and remediating such conduct, and creates more opportunities to train and equip the workforce on preventing sexual harassment. The order also empowers agencies to identify problems, train employees, impose personnel consequences on violators, and to fix or alter chain of command so that there are not people who are involved in a dating, romantic, or sexual relationship who are supervising each other. Before I conclude, I want to remind all employees and DC residents about the DC Victim Hotline. The hotline at 1-844-443-5732 is available 24/7 by telephone, text, or online chat to seamlessly connect victims of a crime to free resources to help them navigate the physical, financial, legal, and emotional repercussions of crime. Again, thank you, Chairperson Bonds, for the opportunity to discuss Mayor Bowser's commitment to prevent and remediate sexual harassment in the district government. I'm available for any questions you might have.
Thank you very much for your testimony, and I'll ask Ms. Kine, do you have testimony also?
I do not, Chair.
All right, okay, thank you very much. I wanted to well, let's talk a little bit about the Department of Human Resources. Let's talk a little bit about that. Can you discuss with us your FTE count and your divisions, because they too are employees, although you're charged with a lot of this follow-up as it relates to the mayor's order?
Sure. So we have approximately 150 persons in the Department of Human Resources. And our divisions, by that if you mean administrations, are the benefits and retirement. We have our recruitment and staffing, which is HRSA. We also have our records, training, and of course, our general counsel, and then the office of the director. We play a vital part in the mayor's order in that we will be responsible for training across the district. That will include the cabinet, that will include general counsel, the shows, employees, which we will work with trainers in each of the agencies to ensure that we have a trainer to trainer model so that there will be a robust training process and program in place. Of course, there will be some reporting that we'll be receiving, and we are also members of the Sexual Harassment Task Force.
Can you remind us what reporting you will be receiving?
Or as you called out earlier, there may be centralized reporting that occurs, and DCHR will be a part of that, in addition to, of course, the Office of Human Rights, MOLC, and we will be making sure that we, of course, adhere to the legislation that is in place to ensure that sexual harassment cases that hopefully do not occur, but if they occur in DCHR, are reported accurately to OHR.
So I'm taking it that we are now, you just mentioned that there are 3 reporting requirements. Indirectly, you said that you're going to be gathering some information. I know you're going to report those who have completed the training, if nothing else, right? Okay. And then you've got a report that goes to, if there is an infraction, that goes to the MOLC, correct? Okay. All right. I'm trying to understand how does all of these reports get processed? I'm now moving into the world of the FTEs. Are we saying we need a dedicated show in each department or agency that's full-time? Do you anticipate that? Because remember, an individual might make a complaint, which does not end up being an actual report of a situation, but an individual might say, well, I think you need to talk to him or you need to talk to her. And I'm just wondering, are we being realistic about the time and energy that's needed to, at least initially, to clear up some of these concerns that individuals have in the personal relationships in an office?
Got it. So I think one of the things that is called out in the new mayor's order that but was implied in the old mayor's order is that a show in any agency can be utilized for an employee. So because every agency will have a primary and an alternate, and persons can go anywhere within the district, I think that right now we have no problem saying that we have a sufficient number of shows and access for employees.
All right, I'm looking now at some of the agencies that have exceeded, let's say 30 actual claims that were filed, like MPD, public schools, you know, as an example. I'm just wondering that those are large organizations. Do you have any thought about how the labor would be dispersed there?
So I would say that those are independent agencies and we don't serve as the personnel authority for those agencies. However, one of the things that the mayor's order is very clear about is that independent agencies can follow what is outlined in the mayor's order. They can add to it based upon what they believe their agencies need, or they can create a process for themselves as well.
All right, I appreciate that response because I wanted the public to understand that we are talking about the agencies under the purview of the mayor, direct line of command. And as I think a previous testimony, there are independent agencies that do tend to create their own, you know, okay. I just want people to understand that because that becomes important when you think about the government as a whole. And that's where we are at the council, thinking about the government as a whole now. So I just wanted to bring that to your attention. Well, I did have a question about your testimony. You just please bear with me. Are employees expected to say no or to ask an offending employee to stop the action before they file a claim? Is that how it works?
Let me make sure I understand the question. If I may repeat it back, does an employee have to say something to the person who's committed an offense before they can report it? No.
Okay, all right, that's it. Wanted to make sure. So you think it would be helpful if an employee at least went on record saying, well, I told him to stop, or I told her no? Do you think that would be helpful?
I think it depends on the circumstance and the employee. What we want to keep in mind is that we provide employees with an environment where they feel safe, and they believe that it's a healthy environment. And an employee may not feel safe enough at that moment to state something. And so we want to make sure that they understand it is not their requirement to do so, but they have avenues where they can report and it will be addressed by those avenues.
Okay, I hope everyone heard that, because that's really an important element of the mayor's order, the old mayor's orders as well, I believe. So I appreciate that. Now I'll go to my standard questions. And thank you all for your indulgence, please. Ms. Noteware, what is the status of your agency on meeting the deadlines? That is, the deadlines that you're now going to be, I guess, somewhat challenged with as it relates to, I think the first one is it was the 12th. Now you're moving to the December deadline. Do you see your office being able to keep up with this? Of course, they're going to be filing with the Human Rights Office, but they're also to file with you.
Are you speaking about the giving notice of any relationships that may be prohibited by the mayor's order, the 2023
Yes,
mayor's?
correct.
Okay.
Yes.
I don't anticipate Mulk having any difficulties handling receiving these notifications of
All right.
relationships. Yeah.
Okay. All right. Just want to make sure I'm clear on that. Can you discuss, please, your agency's participation in establishing the sexual harassment task force?
Sure. So the previous mayor's order contemplated a working group about these issues of sexual harassment, but it was never explicitly stated who the members of the task force were. And we had informally consulted on these various issues with training and drafting policies and things like that previously under the previous mayor's order, but now explicitly as a member of the sexual harassment task force, we are a part of this group of agencies that are tasked with designing the training that will be implemented, and drafting any implementing regulations and addressing any issues that come up in terms of how to best move forward the mayor's policy.
Right. Mr. Hall, could you explain what a healthy and safe workplace looks like and whether we already have that, or is it something that can be achieved equally across the government? And this is sort of like a discussion. You don't have to be tight about it.
Sure. Sure. I think a healthy and a safe workplace is an environment where persons can come and know that they are going to be able to establish relationships that are genuine, that will help them both in their personal life and their professional life, and that you can, create a family of sorts at work, where people know that they are seen as people and not just as people who produce an output, but they are seen as people who are valuable, who are unique, who have an opportunity to serve and contribute to the government and the work that we do here. I believe that we have a healthy and a safe work environment. Are there places where we can make improvements? Of course. I don't think that there's a workplace on earth that cannot make improvements. And that is one of the things that the mayor's order helps us do, is to ensure that we're constantly reviewing what's the status of our workplace, and through the work group, thinking about how can we make it better so that it continues to be a safe and a healthy workplace.
Please distinguish between sexual harassment and non-sexually based harassment in our workplace. I know all three of you have seen that or heard of that. And so if I could get a comment from each of you, I would appreciate it. Start with you, Mr. Hall.
Okay. So I think the mayor's order outlines what sexual harassment would look like under the order. And so as I talked about in the testimony, it could go anything from language to touching, sexting, displaying sexual organs, those sorts of things. I think non-sexual harassment could be, bullying or disrespecting someone by the way that you talk to them. Those are several examples of what I would use to define non-sexual harassment. And under the mayor's order, understand that there's a different definition and a higher standard beyond the mayor's order as it, relates to legal standards.
When we were reviewing some of the comments, of course, I want everyone to know it's redacted. Couldn't tell you the date, time, or whom, but some of the comments indicated that it was really maybe like a misunderstanding, or this wasn't translated right. So that's why I'm asking that question. I know that we all are part of this government and we want to protect this government, but if we don't loosen up and deal with the realities of the situations that occur or can occur, we will not get to, I think, the real explanations that we need to have, and the situations that may occur. Ms. Noteware?
Yeah, I think you're right, Chair Bonds. I think we see that some of the sexual harassment complaints that agencies receive do not meet the standards of sexual harassment, right? They're not considered sexual harassment either under the mayor's order or under Title VII or the DCHRA. But it's important to us as an employer when we're doing these this personnel investigation of sexual harassment to encompass, the whole possible gamut of what could be perceived to be sexual harassment. And we would rather people report things that turn out not to be sexual harassment than fear reporting or feel that they have to meet some kind of high standard in order to report it, because we may be able to address less serious personnel issues in the course of investigating it as sexual harassment. We may discover that there's a communication problem between two employees that we can then address. But we would rather err on the side of over-reporting than under.
I appreciate that. When I had an opportunity to speak with a representative from MPD, they pointed out their proactive approach, where just through observation, being in an office, they were able to speak to one of the employees and say, well, you know, you're leaning mighty close. You might want to sort of push back a little bit when you're speaking to that individual, because I'm just trying to think of the many different situations that we might encounter. We know that we have we're humankind. That's what we are. We cannot we cannot police patrol, you know, our human behavior, but we can be really clear, as I think, you know, many of the provisions in the mayor's order articulate, but still you have that where folk are just not sure. One of the areas of concern seems to be where third party can actually say, well, I think Mary, person A and person C there's a problem there. And that person who's reporting is individual E, have no relationship whatsoever, but they think they heard something or they saw something that might give them a clue. And so do you think the order goes too far by saying if you see something, hear something, think something, that you can report it?
No, I don't think it goes too far. I think that for the same reason that I articulated in the sense that we would rather someone report something and it turn out to be nothing, right? Or it turn out to be a misunderstanding, because that helps us to ensure that we are keeping the workplace safe for all people. I think in terms of fairness, I think we have to remember that these are allegations, right? We can't ever treat a claim of sexual harassment to be, you know, it is sexual harassment. And that's why we have to be careful in how we treat the parties and keeping matters confidential and all of those issues to ensure that it is a fair process for everyone. But at the same time, taking it seriously when we get these claims so that we can make sure that we can stop anything before it might turn into sexual harassment.
So, Mr. Hall, in your capacity doing the training, how do you train for that?
Yeah, so I think part of what the training can include is ensuring that we're aware of the uniqueness of personality, that everybody has a distance that they have a preference for. Everybody may not want to be greeted by a hug. So the persons are emotionally in tuned as they interact with other persons. And that is part of the training that already occurs and will continue to occur for all levels of persons here in the government.
Let me ask you then, are hugs prohibited under the mayor's order?
Hugs are not prohibited in the mayor's order. I know that I want people to be clear that that was an example given where an employee was instructed that they have a behavior that has been flagged and makes someone else uncomfortable. And that was simply an example that is used in the mayor's order.
Thank you very much.
You're
I hope some of the agency directors that I hug heard that and we'll be able to act accordingly. Thank you. How do you have sexual harassment without bullying? How do you have sexual harassment that doesn't touch on retaliation? If I don't comply, you might retaliate against me. Even if you were buying me a milkshake at lunchtime and now you're not going to buy me a milkshake. Or how does that work? Are those elements of retaliation and bullying elements of harassment, or are they elements of sexual harassment, or are they both?
I think with retaliation, it depends on whether or not the retaliation is in response to filing a claim, right? Perhaps you filed a claim of sexual harassment. That's a different type of retaliation. There can also be retaliation in the sense if you're opposing sexual harassment, let's say you refuse to go along with some sexual harassment, and then you suffer some kind of adverse employment action, that can also be retaliatory, but that doesn't always occur. So you can have sexual harassment without retaliation. And likewise for bullying, bullying is not always, sometimes with sexual harassment, it can be a consensual relationship that is no longer consensual, right? That wouldn't necessarily constitute bullying, but it would be sexual harassment still.
Thank you very much. Do you care to add, Mr. Hall? I mean, it's not a requirement. I was just wondering if you wanted, or Ms. Kine, you have anything to add to that? You've seen a number of different kinds of cases. Is there any words of wisdom that we can share with the employees so that they know that just might touch on?
I don't have anything much to add. If anything, just to make clear about the process between, the mayor's order, the policy, the employer policy, as Ms. Noteware put it, personnel investigation versus our office providing a legal remedy that includes things like damages. So that's the only big difference that I would want to remark on. And just one other note that I forgot to mention earlier, which is that OHR does not have any sexual harassment complaints against us. So just wanted to make clear for the record.
All right. Do we have any complaints against human resources?
I believe we submitted a report, and I think that there were claims, but I don't think that there was anything that was substantiated.
All right. And how about the office that receives the reports, Ms. Noteware?
Internally, we have no MULC complaints of sexual harassment, but we do feel like most of the agencies have been complying in submitting their notices of sexual harassment complaints and then their findings and conclusions.
All right. You note at the beginning, I mentioned that the number of claims that we were able to examine, 354 allegations. Does your report show that? I mean, is that where we are today? I mean, recognizing that we're beyond September of 2023, have we had any additional?
I would have to confirm that with our tracker in our office, but I can get back to your office within a few days.
All right, that would be very, very good. I just want the public to understand the 354 number is over a 5-year period. And so it'd be interesting to see if we're ticking up or ticking down. I'm hoping ticking down. Who, Mr. Hall, who in your office is responsible for implementation and compliance of the mayor's order? Is it your general counsel or some other?
When you say who, do you mean, is there a responsibility given to the
Yes,
individual?
yes. I mean, not by name, but officer who. Okay.
Yes. So our general counsel will be leading the charge on that, as they have in the past with training shows, and they'll be working with other general counsels and the Office of Human Rights.
Okay. If you look at the mayor's new order on page, it's 1819, item 7, what provisions of the order impact your agency?
Is it page 18?
18,
7?
19. Mhm.
Page 19?
Yes, it's starts, I guess it's the chapter talks about the rights of the alleged harasser.
It's not,
17, okay.
I think we have different pages, Chair.
Oh, sorry.
Oh, 17, right? Yeah.
So it's 17, 18?
Yes, so a couple of things. I would note that the rights of the harasser in the mayor's order here speaks to the legal process. And so I think that we should keep in mind that the show process is not a legal process. And it also notes that there may be an investigation where appropriate by OHR. And so DCHR would be a part of any show process if we needed to support agencies, but under a legal process that would not include DCHR or the shows.
And again, I think it's very important to make that point, because human rights, human resources, a lot of confusion in the public's mind. So I want to make sure that the processes are clear. Yes.
I just want to
Ms. Kine,
clarify,
yes.
thank you, Chair, that what that's referring to is if an alleged harasser feels that they themselves were a victim of discrimination by virtue of being accused of being a harasser, they could file a complaint at our office, for instance, based on sex or gender or sexual orientation or gender identity. And so then we would then, of course, investigate pursuant to our regular procedures for those types of claims.
Thank you very much, because I know there's going to be a little bit of confusion with the acronyms that we're so famous for in our government. Okay. So, Mr. Hall, do you foresee budgetary constraints in implementing the mayor's order?
I do not.
I knew you would say that, but I mean, just think about it for a minute.
So again, the primary and the alternate show is a member of the staff at agencies already. The relationship designee is a member of the staff already. Our DCHR staff that will be working with OHR, the MOLC, we are in place and have been overseeing training. And so this is a continuation. A lot of this is not necessarily new. So I don't foresee any budgetary constraints.
So you have adequate FTEs?
At DCHR?
Yes.
Yes, ma'am.
All right. And once you make a check of all of the agencies under your purview and with MOUs with you, you will be able to determine whether or not they have adequate staff to carry out the mayor's order if need be.
Yes, and this is one of the places where the mayor's order actually helps us, because if an agency is too small to identify a primary and an alternate, then they can also, work with another agency and have that agency serve as the primary or alternate show.
So what would constitute a too small agency? Is it 5 staff members or 20 staff members or?
I think that it varies. I think what we want to keep in mind is that with a smaller agency, especially if it's, 4 people or something like that, it becomes harder for there to be a level of confidentiality. And so enabling a larger agency to handle the show responsibilities insulates the employee and gives them the ability to not have to worry about someone else finding out or being the recipient of a report.
Well, you may recall, thank you for that. You may recall when we had our working meeting, there was some discussion about there being a dedicated position in the deputy mayor's offices. But I think I made it clear today that deputy mayor for human, human Health and Human Services and for Public Safety did not respond. We don't have their, and the city administrator. So I'm just wondering if that is something that we should continue to think about. We being at the council level, what do you think about that?
I think that I'm not on the council,
I know.
and that is not a question that I would be able to respond to.
All right, okay. But as a consolidation of personnel, do you see that kind of system working? Where if you're in a cluster and you're a small agency within the cluster, that you could automatically look to a show being designated at the deputy mayor level? I mean, do you see it working? That's really what I'm more.
I was just going to jump in to say, I do think one of the strengths of the new mayor's order is that an individual can go to a show anywhere. So they're not limited to just at their agency or even within their deputy mayor cluster. They could go to any show, which I think might make some people feel more comfortable.
And I agree. And the old mayor's order, I think, stipulated the same thing, go to the show. Go anywhere in the, I think with 3 different locations that were defined as you could go to file a claim or to complain. So you think it works?
I think in practice that might be what happened, but I think the previous mayor's order did instruct you to go to your agency show.
It did.
So I think this does give some more flexibility, and I look forward to seeing it, how it does help, or if it does.
All right, okay. All right, I think we have torn apart the mayor's order and answered many questions that we have. As I mentioned to Ms. Davis, and she responded when I said I had a block of questions. Yes, we do. Ms. Kine, could you please tell us what is the status of the data collection for the reports that you expected, I guess, Monday?
Right. So as I mentioned earlier, the deadline was just yesterday. And so we're in the process of compiling the information and contacting agencies that may have missed the deadline.
All right. Could you let us know what your findings are in the next 10 days, please?
Do you mean let you know the status or?
Yes, the status.
Okay,
Yes,
sure.
of course. Yeah.
Yes, absolutely.
All right. Thank you very much. Ms. Noteware, could you distinguish between the legal definition of sexual harassment and sexual assault?
So I'm with the caveat that I'm not a criminal attorney. Sexual assault generally involves some form of physical force or action to force someone to engage in a sexual act. In terms of sexual harassment, as we've discussed here, it can be verbal, it can be display of photos that are suggestive and things like that. So it doesn't necessarily need to have a physical component to it in order to be sexual harassment.
All right, well, okay. I go back to the information that was provided, the 354 allegations, 277 were verbal and 77 were physical. So how would a sexual harassment physical, how would that, what does that look like?
What does the conduct look like, or what does the investigation look like?
The conduct, of course. What we're doing, what we made a commitment to do through this hearing is to try to bring as much understanding as possible to the employees of our government. So I'm trying to take, terminology and give some examples so people will know what is or is not, well, what is not acceptable, I guess is, that's why I'm asking that question.
Sure. I mean, I think I can't speak to specific cases, obviously, but I think some behaviors that we've seen that were complained of were like shoulder massages, right? That someone didn't ask for, or someone, brushing up against their backside, or unnecessarily like touching them during conversation. So it's not always sexual assault, right? But there are physical behaviors alleged and complained of.
And I would imagine that would include body parts exposure and stuff like that.
Yes.
Okay, okay. So does the Office of Legal Counsel receive reports from the independent agencies?
So we receive two things from each agency. They should be submitting to us a notice of a complaint. So there's a form we use for that where they outline this complaint's been made. They describe what the complaint is. They say who the show was that it was assigned to. So we have a notice of when they've received the complaint. They should be doing that as soon as they receive the complaint. The other thing that MOLC receives from each of the agencies is the agency's findings and conclusions. And that's what they issue at the end. After an investigation has been done, the agency submits to the parties the findings and conclusions, informing them of the results of the investigation. And MOLC receives a copy of that as well.
And this is for all of the agencies, including independent agencies?
This is for all of the agencies that are subordinate to the mayor.
Okay,
Mhm.
all right, okay. So in other words, certainly the courts do not notify MOLC.
Correct.
And let's say DC Water doesn't notify the MOLC.
That's right.
What about the Housing Authority? That's independent.
Right. I would have to look. Some independent agencies have submitted to MOLC. They've chosen to adopt the mayor's policy as their own. So we do, for instance, receive or we have received notices from the libraries. But I would have to check to see if the DC Housing Authority specifically has chosen to do so.
All right. Okay. Thank you. So basically, we are not at this point under any requirement to share the mayor's order with the independent agencies, those that are not subordinate to the mayor.
I think the mayor's order invites independent agencies to adopt it and instructs them, if not, to develop their own process then. So I don't know that it's, I think the mayor has at least advised them that they should have some policy, even if they've not adopted hers.
Okay. All right, well, we want to thank you all very, very much for participating with us today. And get to my script. I believe we've learned valuable information about the government's workplace culture and how we address issues of sexual harassment and related complaints. I hope the public feels more confident as to how the new Mayor's Order 2023-131 will be implemented, and that our government does not tolerate any form of inappropriate workplace conduct between government employees and members of the public. If any current government employee would like to submit written testimony regarding the performance of this mayor's order, says agencies, but the mayor's order, please email it to CEAL@dccouncil.gov, and that's CEAL@dccouncil.gov. The hearing record will close in 10 days. That is on Monday, November 27th, 2023 at 5 p.m. And that concludes our hearing for the day. And the time is 3:20 p.m. Thank you all again. Thank you very much.